Greetings. Thank you for joining us with another episode of the People's Law School. Today we are going to be talking about Social Security disability claims and procedures. I'm Craig Housman. I'm a lawyer practicing here in Paducah. I have been practicing here since 1973. A substantial and regular part of my practice has been Social Security claims throughout that 34-year period. With me to help present this program to you today is Denny Fentress. Dennis is a lawyer with the Francis and Fentress law firm. Dennis is a graduate of the University of Louisville School of Law. After spending a year working as a staff attorney with the Social Security Administration, Dennis joined the Francis and Fentress law firm in 1990 and has been exclusively representing people with Social Security disability claims for the past 17 years. Dennis, I guess the best way to start this is what programs, plural, does Social Security administer whereby benefits are paid to people who have disabilities?
Well, Craig, as you know, there's basically three types of different programs. The Title II program, or the disability program, for those individuals who have worked, paid in the Social Security program, and then become disabled. The other programs are for the SSI recipients. SSI is for individuals who are disabled and meet the financial requirements. Basically, they haven't worked and they are disabled, but they have no income and limited resources. The third type of program is for the disabled widows. Those individuals, male or female of course, between the ages of 50 to 60 who become disabled and meet some other qualifications regarding marriage, they're also entitled to receive benefits.
Okay. One of the things that I guess we need to discuss is what does it take to be disabled by Social Security's standards? First of all, in an overall sense, is there any such thing as a partial disability with Social Security?
As you know, again, no, and that's probably one of the frequent questions you get in your practice. We're always asked, well, I can't do this, but I can do something else. But for Social Security, it's pretty much all or nothing. Either you're totally disabled and unable to work, or you're not eligible. And Social Security's, I guess their definition of disability is maybe different from ours, or even the doctors. As you know, I'm sure you in your practice, you have clients come in and say, well, my doctor says I'm disabled, but I guess what does that mean to Social Security, though?
Okay. Well, Social Security has a simple sounding definition of disability. It is an inability to do any substantial gainful activity due to a medically determinable impairment that has or is expected to last 12 continuous months or result in death. And each part of that definition has particular meaning. And when we talked about the person's physician saying, well, I think you ought to go on disability, or I think you qualify, or if the patient has asked them, they think they will do what they can to help. What does it mean in practice when Social Security says that in order to be disabled, it must result from some medically determinable problem?
Well, you have to have what's considered a severe impairment, an impairment that affects your ability to work. And severe impairment can be related to any condition, mental, visual, hearing. Of course, the predominant injury is always going to be the back, or is what you see more often. But any condition that keeps you from engaging in work activity on a sustained basis.
Okay. The predominant claim that I see from a physical standpoint, I guess, would be people with either back or low back or neck injuries that have had surgery or some ongoing chronic problem. But then there's seemingly an overarching area of disabling conditions that arise from mental illness that seem to go often hand in hand for folks who have dealt with chronic pain for a long time. How does one go about establishing that they have a disability from this, for excuse me, for purposes of establishing entitlement to Social Security benefits? Can you take in a prescription pad slip from your doctor saying this patient's permanently and totally disabled, signed Dr. Jones, MD?
Well, from the guys that I've talked to, practiced 30 years ago or 35 when the program first started, you could actually do things like that. But under the law, no. Of course, the key is the doctor's opinions. Either your doctor, Social Security's doctors, are the key to the situation, and their opinions have to be based on objective medical findings and tests. The doctors need to say specific work restrictions. Lifting no more than 10 pounds, sitting no longer than an hour out of an 8-hour day, standing, same thing. So the key is to get specific restrictions from your doctors to say that you cannot do this type of activity. And on the mental side of it, you can't concentrate, you can't focus, can't maintain attention. You need to get the docs to say that and back it up with the medical records and objective tests and findings.
Okay. I know that in our experience, the extent to which you can get the treating physician to not only specify specific limitations that they think their patient has in terms of normal work requirements, but also the extent to which they will back that up with some sort of medical rationale. This test tells us that this patient has this problem, and patients with this problem are limited in this regard. Or my experience is that patients who have these findings on x-rays typically have ongoing severe pain and require this type of medication to deal with it, which has these side effects which would interfere with their ability to concentrate or their ability to show up regularly at work or that sort of thing. To what extent does it make a difference whether or not a person who thinks he or she may be entitled to Social Security disability benefits gets a lawyer to help?
Well, statistics show you're more likely, significantly more likely to be awarded benefits if you have a lawyer to assist you. And I guess the issue is, when do you start the process and when do you get the lawyer? So when our clients, we generally recommend getting a lawyer if you're denied. Sometimes if the client has a special problems, maybe they don't understand the system, they're functioning at a lower level intellectually, then maybe you would need a lawyer to help you at the initial level. But generally, a claimant will be capable of filing the application, and the Social Security will review it and make a decision. And if that decision is not favorable to the claimant at that time, we generally advise them they do need to get an attorney. And then when we get at least to the hearing level, you definitely need an attorney. But I guess I'm kind of jumping ahead. Maybe we ought to go with the process first on how it gets started.
Okay. You know, the way the process gets started is the simple task of calling the local Social Security office in Paducah. It's out in Lone Oak, and you make an appointment and go out and fill out an application, at which time they will ask you in some detail about what all's wrong with you and what medical providers you have seen, what tests you've had. And one of the things people don't always expect to be questioned about, but is very important, is their past work. And Social Security is only interested in the last 15 years of their employment before the point where they became disabled. But that is something that people should give some thought to before going out and talking with them at the district office and filling out the initial claim. Then once the initial claim is sent in, I think you were telling me that you had some figures on how long it usually takes to get a response from the initial application?
Usually in Kentucky, now all the states vary, but usually we're talking about 3 to 6 months before you get the initial decision. And nationwide, the allowance rate is around 35%. The people that file the claim are found disabled. I think in Kentucky it's below the national average. It's only about 30%.
Okay.
And like we were saying before, at that time it's generally advisable to get an attorney to help with the appeal and then help develop the evidence.
With or without an attorney, what's the success rate at the second step, the reconsideration level?
Again, nationwide it's 13%. So it tells you you're not likely to be found disabled at the second step. In Kentucky, it's again below the national average. They're running about 9% according to the last statistics that they had. So I generally always tell my clients to expect to get a denial at the second level. It's just, you're just more than likely that's going to happen.
I know that from our experience, the real benefit of being involved at the second step is every now and again, by pointing out some obvious error in the state agency's analysis, we are able to get a successful result at the second step. But even if we're not successful at the second step, it gives us a better or a longer length of time within which to get prepared and get the necessary medical explanation and medical evidence for the hearing step, which, as I understand it, is the third step in the process. How important is it to the potential claimant to have a lawyer when they get to the hearing stage before an administrative law judge?
That's really the key. You really need an attorney when you go before the judge. This is the only opportunity you have in the entire Social Security process to see the person who's going to decide if you're disabled or not. You actually have a hearing, an opportunity to present your case, tell the judge, who is an administrative law judge that does nothing but Social Security, tell this person why you're not able to work. And the judge applies the law and makes a decision whether the individual is disabled. So it's extremely important at that level for it to be represented, to have an attorney help you prepare for the hearing. But again, more importantly, probably to help you develop the record. You got to get the medical records. You got to get the support from the doctors and the mental health professionals to say that you can't sustain a job, and that's the key. A lot of times in the process, a case is really not ripe, as you probably know, until you get to the hearing level. You'll have a person that has a back injury and they have surgery. Well, if they do well before that required 12-month durational period, then they can go back to work, of course, and they won't be eligible for benefits because they hadn't been disabled for 12 months. We see that a lot. Also, a lot of times, sadly, with, well, I guess not sadly, but with cancer patients, the treatment, if everything goes well, then a lot of times they can go back to work before the 12-month durational period. So a lot of times the case is not really, I guess, ripe to be decided until it's been close to a year, or at least a year. And by that time, you're generally at the judge's level.
One of the things that I think it's important for people to realize that may not be very widely appreciated, and that is the hearing level, when you go before the administrative law judge, is the last time that you can put into evidence any medical record that you want included. It is the last time you can put into evidence any other item that you think is important to establish that person's claim. Because at the step beyond the administrative law judge, that's with the appeals council in Falls Church, Virginia, and then beyond that you have to go to federal court. But with the appeals council and in federal court, if you want to submit something new, something additional, you not only have to come up with the new and additional evidence that's important, but you have to explain why you didn't present it at the third step, because to an increasing degree the Social Security Administration and the federal courts are enforcing a requirement that you need to make your case at the administrative law judge level, and they are pretty stern about putting in all the evidence that you think you're going to need at that step. We talked about the 12-month durational level. What about the fella who gets hurt, has back surgery, his doctor says, I think you can go back to some light duty work, and the guy actually goes back and tries it, maybe lasts 6 weeks. And at this point it's 8 months into the process, but then he finds that he can't do the light work and he's out of work again. Is the fact that he went back to work for a relatively brief period of time within the 12 months, does that destroy the durational requirement of being disabled for 12 continuous months?
That's a good point, and no, it doesn't. It just depends on how long they work. Usually, if you try to go back to work and you're, like you said, the example, you're not able to do it, Social Security will consider that an unsuccessful work attempt. If you do that, try to go back for up to 3 months and you can't do it, you stop because of your health problems. It has to be because of health problems, not because you don't want to do it anymore. But if you do stop working before 3 months, it's generally automatic that it'll consider it as an unsuccessful work attempt and your Social Security case can continue. Then you can go up to 6 months and you have a little bit of an additional burden to carry on at up to 6 months, but generally too at up to 6 months, if you're not able to maintain the job, again because of health reasons, they'll consider that as an unsuccessful work attempt, and you can continue on with your Social Security claim. I've had a few cases, not that often, but even beyond 6 months, if a person continues to work, they can still be considered and continue with their Social Security case if they're given special accommodations at work. You may be working for a family member. The family member allows you to take extra days off, go back and lay down when you need to. But that's a little bit harder burden to show. You've got to get a lot of different evidence in from the employers and all to demonstrate that these special accommodations are granted to you and the actual worth of the work that you're providing your employer is not that valuable. So there are situations where you can even work that way and go beyond the 6 months and still be considered. But that happens some at the judges level. But in your situation here in Paducah, about how long have you been your experience as far as to have a hearing and at the administrative law judge level and processing?
From the time that the person asks for a hearing, which is initiating the third step, in the past it has been a little slower at times and it has been a little quicker at times, but generally we're running 8 or 9 months from the request for a hearing until the time that a hearing is actually scheduled. One of the things that, as a service to the folks who are listening to this program, we need to get across is to what extent will common sense serve you if the person chooses to represent themselves in front of the administrative law judge. You know, if you go in, my doctor says I'm totally disabled, I've been a truck driver all my life, and he says I can't drive trucks. Isn't that enough?
Yeah. Well, I think that at least when I worked at ODAR, and it kind of frustrated the judges because it made them, their hearings, a good part of the hearing was taken up by explaining to a claimant that that's not the law. You know, it's not enough that your doctor says you're disabled. Social Security has their own definition for disability if you're disabled. So they prefer, of course, to have a representative to be able to explain to the claimant before they get to the hearing what the law is, what you've got to show to win your case. So that's why I think it's beneficial, at least at the hearing level, to have an attorney. One thing that I want to point out too, we're pretty lucky really in Paducah to have the ODAR here. We just got some statistics indicate that their processing time is they're ranked 18th, I think, out of like 140 some offices nationwide. So while 8 or 9 months is too long, it's a long time. Paducah, we're pretty lucky because they're one of the fastest processing offices in the country, and it's even more so. As you probably know, I don't think they've really been able to hire anybody for the last 9 or 10 years, so they really do a pretty good job. We're pretty lucky. We go We have hearings in other areas like Evansville and Nashville, and we're just pretty lucky to have the Paducah staff that we do.
I wholeheartedly agree. Are there aspects of the Social Security disability standard that are counterintuitive or are different from what one using common sense would expect the rules to be? I know the one that I hear all the time is, why, I must be disabled, nobody will hire me. Who's going to hire somebody that's got a problem like mine? To what extent will that observation or argument be successful with Social Security?
Not at all. And I'm sure in your 30-some years of practice, there probably hadn't been a day that hadn't gone by that you've talked to a Social Security claimant that says, I can't get a job or nobody will hire me for a job.
Right.
But for Social Security, that's not an issue. It doesn't matter to them that there's no such jobs in this area. It doesn't matter what a job pays. It doesn't matter that nobody will hire you for the job. I think a good example is one that we've talked about before at Fisher-Price when they were in Murray, people assembling toys. A lot of those jobs allowed people to sit and stand and made special accommodations for them. Well, those jobs aren't here anymore. They're in Mexico. But if you did that job, and even though that job's not here anymore, if you're able to do that job physically and mentally, you're not disabled. I think one of the best ones that it's kind of a sad case was a guy who worked for all his life as an elevator operator. There's no such thing as an elevator operator now. I mean, I'm nearly 50 and I can remember as a kid, going to a big store or something where an elevator operator was there and ask you what floor. Well, I've never seen one, since I was 5 or 6. But this person, that was their job. And they lost their job, obviously. And the person was denied Social Security because he could go back and do that job, even though there's probably no elevator operator in the state of Kentucky. But it's not an issue. It's not an issue.
It's just one where, for political reasons, Congress changed the act to preclude the consideration of hiring practices in determining whether or not someone is disabled. So it's not that the folks at Social Security don't care, it's the fact that the way Congress set up the program, they can't pay any attention to that argument. There are some ways in which the Social Security law is artificially favorable, such as at certain age brackets, the rules change in terms of determining who is disabled and who is not. Would you address that, please?
As a general rule, the older you get, the easier it is to get your Social Security, generally. Now, there's exceptions, of course. But the first issue you've got to overcome is, can you do your past work? Now, jobs like our jobs are more of a sit-down job. So we have to show we cannot do a sit-down job before we can go on and see if we can do other jobs. Once you get 50, though, if you cannot do your past work and your past work does not provide you the skills to do a sit-down job, then a person will generally be found disabled if all they can do is a sit-down job. So even though they can do every sit-down job, unskilled sit-down job that exists, they're still disabled at 50, while at 49, they're not disabled. So the law does help in that way. The older you get, makes it a little bit easier. At 55, even easier. Again, you have to show you can't do your past work, but if all you can do is a light duty type job, again, you're generally going to be disabled. But you get other factors involved, your education, will it provide you the skills to do a different job. But I guess we're kind of getting in the sequential evaluation process on that, so maybe explain that, how it works, right, and what you got to prove.
Basically, Social Security asks 5 questions in the process of deciding whether or not a particular claimant is or is not disabled. The first question is, are you working? Because frankly, it doesn't matter what's wrong with you if you are still working. I guess the best example I can think of is Max Cleland, who was the head of the Veterans Administration and then became a senator from Georgia. And this is the fellow that I think we've seen on TV programs who lost both legs and one arm when he jumped out of a helicopter in Vietnam. But because of the strength of his intellect and his personality, he was able to nevertheless be productive and stay regularly employed in administrative and executive type positions. So as long as he's still working, he's not eligible. So first question is, are you working? Second question is, do you have anything significantly wrong with you? If you go in and say, I have a hangnail and periodically get headaches, unless they are really severe headaches and you've got some medical documentation to establish the severity of those, they will deny your claim simply because it's not sufficiently severe to reasonably be expected to interfere with your ability to perform in the workplace. The third step is, do you meet the medically listing of impairments appendix criteria, which is if you have this disease or this diagnosis and you have these medical findings, they will presume you are disabled so long as you're not working. You know, they have this for virtually every body system. You know, kidney failure, if you're the chemistry tests on your urine shows that your kidneys are below a certain level, then they will pay you. If you have visual problems and the best corrected vision is 20/200 in the better eye, then that's presumptive disability. Then the fourth question is, can you do your past relevant work, regardless of whether or not it still exists or you would be hired? And the fifth question is, can you do anything else? And that's the reason that when most folks go to a hearing with the administrative law judge, there's a vocational expert present. And he is to advise the administrative law judge whether, under the restrictions and limitations that the physicians have established for this claimant, there are still nevertheless jobs that that person could do, or at what point do they reach the stage where there are no jobs realistically.
How about a hearing? I have a lot of clients who ask, well, what happens at a hearing? What's a hearing like before the judge? Again, this is the only opportunity you have to actually see the person that's going to make the decision and tell them your problem.
Okay. The hearings vary greatly in length. I've had them run anywhere from 10 minutes to 3 hours.
Does the judge have any influence on how long a hearing will last?
He has all the influence. It is his show for the most part. But I'm afraid we have just about exhausted the time that has been allotted to us for this discussion. And we want to thank the folks who have been listening to us for the past half an hour. And I want to remind you again that this has been a presentation brought to you by the McCracken County Bar Association along with WKET. And this has been the People's Law School. We thank you for your time and attention.